Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal advice. The history of divorce law involves complex shifts in legislation, social policy, and individual rights that vary significantly by jurisdiction. This documentary explores historical trends and case studies from the 20th century to provide context on the evolution of the legal profession. Viewers should conduct their own due diligence and consult with a qualified licensed attorney for any personal legal matters. In 1905, if you walked into a mahogany row law office in Manhattan and asked for a divorce, you weren't just asking for a legal filing. You were asking a professional to help you commit a socially sanctioned act of perjury. At the dawn of the 20th century, the divorce lawyer was not the high-powered, televised negotiator we recognize today. They were often viewed as the vultures of the legal world, operating in a fault-based system that required one spouse to prove the other had committed a moral atrocity, adultery, cruelty, or abandonment. If both parties wanted out simply because they had grown apart, the law quite literally would not allow it. To win a case, lawyers frequently had to hire professional witnesses or stage elaborate photographs of adultery in hotel rooms just to meet the evidentiary standards of the court. We are going to peel back the curtain on a century of legal warfare that transformed the American family forever. We are tracing the journey from the divorce mills of Reno to the high-stakes boardrooms of the 1990s, revealing how the role of the divorce lawyer shifted from a shadowy fixer to a social architect. Understanding this history is not just an exercise in nostalgia. It is a critical deep dive into how the American legal system manages the most intimate aspects of our lives. For the modern audience, this history explains why your current assets are divided the way they are, why child custody battles take the shape they do, and how the business of breaking up became a multi-billion-dollar industry. By examining these historical trends, we gain a clearer picture of the potential outcomes in today's legal landscape and the hard-won rights that many now take for granted. To understand the 20th century divorce lawyer, we must first look at the rigid, unforgiving world of the 1900s to 1920s. In this era, the lawyer functioned primarily as a proof finder. Because no-fault divorce did not exist, the lawyer's job was to build a narrative of victimhood and villainy. If a wife wanted to leave an unhappy marriage, her attorney had to prove extreme cruelty. This wasn't just a disagreement. It required documented instances of physical violence or mental anguish, so severe it threatened her health. For the lawyer, this meant gathering medical records, finding neighbors willing to testify about shouting matches heard through thin walls, and occasionally manufacturing drama. Consider the New York system of the early 1900s. Adultery was the only ground for divorce. This created a bizarre professional niche for lawyers who worked closely with private investigators. These investigators would follow husbands to social clubs or wait outside apartments with cameras. The lawyer's role was to take these grainy photos and translate them into a legal certainty that would satisfy a skeptical judge. It was a high-stakes game of theater. If a judge suspected that both the husband and wife actually agreed to the divorce, a concept known as collusion, the case would be dismissed immediately. The lawyer's primary skill was not mediation or empathy. It was the ability to navigate a system that actively penalized honesty. As we move into the 1930s and 40s, we see the rise of the jurisdictional specialist. This was the era of the Reno divorce. Lawyers in Nevada realized that while New York and South Carolina had draconian laws, Nevada's residency requirements were incredibly brief. A lawyer's job suddenly shifted from proving adultery to managing logistics. Wealthy clients would be instructed by their attorneys to board a train to Reno, stay in a divorce ranch for 6 weeks to establish residency, and then appear in a local court where the grounds for divorce were much more lenient. The divorce lawyer became a travel agent of sorts, a strategist who knew how to shop for the most favorable laws. This period highlighted the massive class divide in American legal access. If you had the means to hire a specialist who understood the nuances of state line hopping, you could find freedom. If you didn't, you remained trapped in the fault system of your home state. By the mid-century, specifically post-World War II, the role evolved again. The 1950s are often remembered as an era of domestic stability, but beneath the surface, the legal profession was grappling with a surge in filings as veterans returned and social norms began to fracture. The lawyer now had to navigate the psychological turn. Courts began to care more about the well-being of children, leading to the rise of the best interests of the child standard. The lawyer was no longer just arguing about who cheated. They were arguing about who was the better parent based on emerging, and often biased sociological theories of the time. This gave the divorce lawyer a new set of tools: the expert witness. Child psychologists and social workers became staples of the courtroom, and the lawyer's job was to curate these experts to build a profile of parental fitness. The true seismic shift, however, occurred in 1969 and 1970, with the introduction of no-fault divorce laws, pioneered in California. This fundamentally redefined the lawyer's profession. Gone were the days of hotel room perjury. The new challenge was equitable distribution. As the moral question of who is at fault vanished, the financial question of who gets the house took center stage. The 1970s and 80s divorce lawyer had to become a forensic accountant. With the rise of dual-income households and complex retirement accounts, the lawyer had to track hidden assets, value family businesses, and project future earnings. In this decade, the shark persona emerged. With the stakes shifted to massive financial settlements, lawyers like Marvin Mitchelson began making headlines. Mitchelson popularized the concept of palimony, representing the partners of celebrities in non-marital breakups. This era showed the potential outcomes of high-conflict litigation, where the lawyer was a gladiator for a client's lifestyle. The deep dive into a spouse's spending habits became the standard operating procedure. Lawyers would spend months scouring credit card receipts, bank statements, and tax returns to ensure their client received every possible cent of the marital estate. By the time we reached the 1990s, the profession began a slight pivot toward alternative dispute resolution or mediation. The sheer cost and emotional toll of the shark era led to a demand for a more collaborative approach. The lawyer's role became multifaceted: part litigator, part negotiator, and part emotional buffer. They had to manage the expectations of clients who were often fueled by a century of media portrayals of winning a divorce. The reality they taught their clients was that in a modern legal system, winning usually meant a settlement that both parties could live with, rather than a total destruction of the opposition. This part of our deep dive sets the stage for everything that follows. We have moved from the era of the moral fixer in the 1910s, through the jurisdictional strategist of the 1930s, to the forensic accountant of the 1980s. Each phase represents a shift in American values, from a society that prioritized the permanence of the institution of marriage at all costs, to one that prioritizes individual autonomy and the equitable division of property. In the coming sections, we will break down the specific case studies that define these eras, examining the actual court transcripts and the legal strategies that change the definition of family in the eyes of the law. To understand the weight of the divorce lawyer's role, we have to look at the sheer wall of social and legal resistance they faced in the first quarter of the century. Imagine you are a citizen in 1915 named Arthur. You live in a state where the only way to dissolve a marriage is to prove your spouse committed a heinous act. You and your wife have simply fallen out of love. There is no violence, no infidelity, and no abandonment. Under the laws of the time, you are legally inseparable. If you go to a standard corporate attorney, they might turn you away to protect their own reputation. This birthed the first major archetype of the 20th century divorce specialist, the collusion architect. The historical trends of this era show a fascinating dance between the letter of the law and the reality of human behavior. Lawyers had to become masters of the staged scenario. In New York, for example, adultery was the sole ground for divorce for decades. This led to the creation of the raid. A lawyer would hire a private investigator, who would then hire a woman, often referred to as a professional correspondent, to meet the husband in a hotel room. They would be instructed to take off their coats and sit on the edge of the bed. At a prearranged moment, the lawyer and the investigator would burst into the room with a photographer. This staged evidence would then be presented in court. The lawyer knew it was a farce, the judge likely suspected it was a farce, but because the technical requirements of the law were met, the divorce could proceed. This created a legal culture where the lawyer's primary value was their ability to navigate hypocrisy without flinching. The data from early 20th century court records indicates that while the number of divorces was low compared to 2026 standards, the rate of successful filings based on adultery was disproportionately high in states with restrictive laws. This suggests that the legal profession was actively facilitating these staged events as a matter of survival for their clients. The step-by-step process for a lawyer in this era was grueling. First, they had to vet the client to ensure they wouldn't crack under cross-examination. Second, they had to coordinate with investigators who operated in the shadows of the city. Third, they had to draft pleadings that were essentially works of creative fiction, designed to bypass the moral gatekeeping of the judiciary. Moving into the 1920s, we see the emergence of the divorce mill. This was the first time law became a volume business. Cities like Sioux Falls, South Dakota, and later Reno, Nevada, became hubs where lawyers didn't just practice law. They managed an entire local economy. A lawyer in Reno in 1925 wasn't just filing papers. They were a concierge. They would meet clients at the train station, settle them into a local hotel or ranch, and provide a list of local shops and activities to pass the 6-week residency requirement. The legal strategy here shifted from proving a crime to proving presence. The lawyer's job was to ensure that the client's residency was legally ironclad. If a client left the state for even a weekend to visit family, the clock could reset, and the lawyer's case would collapse. This required a level of administrative oversight that would eventually lay the groundwork for modern law firm management. During the Great Depression of the 1930s, the divorce lawyer's role took a dark and pragmatic turn. Economic desperation changed the stakes. Historical trends during this decade show that while divorce rates actually dipped, mostly because people couldn't afford the legal fees, the cases that did reach court were vicious battles over the few assets that remained. The lawyer became a debt negotiator. They weren't just fighting for the house. They were fighting over who would be responsible for the crushing mortgage or the personal loans. Case studies from this period reveal lawyers arguing over the value of household appliances and farm equipment with a ferocity previously reserved for corporate mergers. The 1930s also saw the lawyer as a defender against the criminalization of poverty. In many jurisdictions, if a man could not pay his court-ordered support, he could be jailed. The divorce lawyer therefore had to operate in both civil and criminal spheres, arguing that a client's inability to pay was a result of the national economic collapse, rather than a willful contempt of court. This era solidified the lawyer's role as a shield between the individual and a state that used domestic law to enforce social order. Imagine if, in 2026, every time you wanted to change a contract, you had to prove the other person was a villain. That was the reality every divorce lawyer faced until the mid-century. But as we transition into the 1940s and 50s, the lawyer's toolkit began to expand. The advent of World War II brought about a phenomenon known as the goodbye marriage. Hasty unions formed before soldiers shipped out. When these men returned, the divorce lawyer was met with a tidal wave of cases involving alienation of affection and abandonment. The legal strategy in the post-war era began to focus heavily on the psychological state of the parties. This was the beginning of the lawyer as a social scientist. They started incorporating early psychological evaluations to argue that a spouse was unfit, not because of a specific act of adultery, but because of their nervous temperament or inability to provide a stable home environment. This was a pivotal moment because it moved the goalposts from objective acts to subjective states of being. The lawyer now had to be able to speak the language of Freud and the burgeoning field of sociology to convince a judge. In the late 1950s, we also see the first major push for the Uniform Divorce Act. Lawyers began lobbying for consistency across state lines. The profession was tired of the Reno loophole and the chaos it caused for child custody and property rights. A lawyer in New York didn't want to see their hard-won judgment overturned just because a client drove to another state. This was the start of the lawyer as a legislator and a policy advocate. They weren't just practicing the law. They were actively trying to rewrite it to make it more predictable and less like a theatrical production. Case studies from the late 50s show a fascinating trend: the rise of the private settlement. Lawyers began to realize that if they could get the husband and wife to agree on terms in a private office, they could present a united front to the judge, minimizing the risk of the judge denying the divorce on moral grounds. This was the birth of the modern settlement agreement. The lawyer's role moved from the courtroom floor to the conference room table. They became negotiators, horse traders, and psychologists, trying to find a price for peace. But as much as the lawyers tried to stabilize the system, a storm was brewing. The 1960s were about to explode, and the traditional role of the divorce lawyer was going to be caught in the crossfire of the sexual revolution and the rise of second-wave feminism. The legal profession was about to face its greatest challenge. What happens when the very definition of a woman's role in the home is legally challenged? What happens when a wife's domestic labor is suddenly given a dollar value in a courtroom? We have seen the lawyer as a fixer and a strategist, but the next evolution would turn them into something much more powerful: a financial architect of the new American middle class. But before that could happen, one massive legal hurdle remained. A hurdle that required a complete dismantling of centuries of English common law. In the next part, we will dive into the specific legal battle that led to the first no-fault law, and how one lawyer's gamble in California changed the financial destiny of every American family. We will also uncover the secret underground railway that lawyers used to get women out of abusive marriages before the law caught up with the times. The stakes were about to get much higher, and the fees were about to get much larger. To truly grasp the radical transformation of the 1960s, we have to look at the lawyer not just as a practitioner, but as an insurgent. Before the 1970s, the legal landscape was a minefield of archaic morality. In many states, if a woman wanted to leave a marriage, she had to navigate a system that was fundamentally weighted against her financial survival. This is where the underground railway of matrimonial law began to take shape. Imagine a woman named Linda in 1964. She lives in a state where a husband has total control over the marital assets, and the only way she can secure any future for herself is by catching him in an act of gross misconduct. Her lawyer in this scenario was less of an advocate and more of an operative. They would facilitate secret meetings, advise on how to quietly move personal belongings to a safe location, and connect her with sympathetic out-of-state counsel. This underground network was a direct response to the lack of legal recourse. Lawyers began to specialize in what we now call jurisdictional maneuvering on an industrial scale. They would find the specific gaps in state laws that allowed for the fastest possible dissolution. In historical trends of the mid-1960s, we see a surge in interstate legal cooperation. A lawyer in Illinois would have a trusted partner in Nevada or Alabama. They would coordinate the handoff of a client, ensuring that by the time the husband realized a divorce was happening, the wife had already established residency in a more favorable jurisdiction. This was a high-stakes chess game where the lawyer's primary weapon was the clock. The data from this era reflects a brewing legal civil war. State legislatures were seeing their citizens flee to other jurisdictions to settle domestic matters, which meant a loss of court fees and legal revenue. This economic pressure, combined with the social upheaval of the decade, forced the hand of the legal establishment. Enter the year 1969. In California, a group of legal reformers and attorneys began to argue that the fault-based system was not only corrupt, but was clogging the courts with manufactured evidence. They argued that the adversarial nature of divorce was causing irreparable harm to children and the social fabric. The role of the lawyer was about to shift from a detective to a negotiator overnight. When Governor Ronald Reagan signed the Family Law Act of 1969, which took effect in 1970, it introduced the first true no-fault divorce in the United States. This was the big bang of matrimonial law. The step-by-step process of a divorce case changed instantly. Before 1970, the first step was the accusation. After 1970, the first step was the declaration of irreconcilable differences. This seemingly small change in phrasing shifted the entire economic model of the legal profession. With the moral question removed, lawyers had to find a new way to prove their value. If you no longer need a lawyer to prove your spouse is a bad person, why do you need a high-priced attorney at all? The answer came in the form of property. The 1970s lawyer became a pioneer in the valuation of intangible assets. Imagine a case study where a husband and wife have a modest house, but the husband has spent 20 years building a pension or a professional practice, like a dental clinic. Under the old system, that pension was often considered his alone. In the new no-fault era, lawyers began to argue for the concept of the marital partnership. They contended that every year the wife spent managing the household or raising children was a direct contribution to the growth of that pension or dental practice. This led to the rise of the actuarial lawyer. Attorneys began hiring mathematicians and economists to provide testimony. They would calculate the present value of future earnings. This was a massive expansion of the lawyer's role. They were no longer just arguing law, they were arguing accounting. They had to understand compound interest, inflation adjustments, and the tax implications of liquidating assets. For the U.S. audience in 2026, this is the reason why modern divorce settlements involve such granular detail regarding 401k plans and stock options. Those standards were forged in the high-conflict boardrooms of the 1970s. Let's look at a specific case study from 1975 that illustrates the potential outcomes of this new era. A lawyer represented a woman whose husband had just completed medical school. They had no assets, no house, no savings, only his degree. The lawyer argued that the medical degree itself was marital property, because the wife had worked to support the husband while he earned it. While many courts initially balked at this, it set a historical trend where the lawyer's role was to expand the definition of what constitutes a thing that can be owned and divided. As the 1970s progressed into the early 80s, the role of the lawyer also became inextricably linked with the rise of the feminist movement. Lawyers like Gloria Allred and others began using the courtroom as a platform for social change. The divorce lawyer was now a combatant in the gender wars. They were fighting for permanent alimony and rehabilitative alimony, concepts designed to ensure that a spouse who had been out of the workforce for decades wouldn't be left destitute. The lawyer's job was to quantify the lost career opportunity of their client. In this decade, we also see the birth of the QDRO, or Qualified Domestic Relations Order. This is a highly technical legal instrument that allows for the division of a retirement plan without immediate tax penalties. The creation of such tools meant that the divorce lawyer had to become a tax specialist. If a lawyer messed up the wording of a QDRO in 1984, their client could lose 30% of their settlement to the IRS. This increased the liability of the profession and led to the rise of malpractice insurance specifically for matrimonial attorneys. The stakes were no longer just emotional. They were deeply mathematically terminal for a person's financial future. Imagine if you were a lawyer in 1985. You are sitting across from a client who is devastated by a betrayal. Your job is to tell them that the law doesn't care about the betrayal. It only cares about the bank accounts. This created a new type of professional tension. The lawyer had to act as a de-escalator. If they let the client's anger drive the litigation, the only people who would truly profit were the lawyers themselves through billable hours. This birthed the efficient advocate archetype, the lawyer who tries to maximize the settlement while minimizing the time spent in court. However, the shark mentality didn't disappear. It just rebranded. In cities like Los Angeles and New York, the celebrity divorce lawyer became a brand name. They were the ones who could navigate the complex world of royalties, image rights, and intellectual property. When a famous rock star divorced in 1988, their lawyer had to value the future royalties of songs that hadn't even been written yet. This required a level of foresight and creative lawyering that was unheard of in the 1920s. The data from the late 80s shows a significant increase in the average cost of a contested divorce. This wasn't just inflation. It was the complexity of the deep dive into financial lives. Lawyers were now subpoenaing records from Swiss banks, tracking down offshore shell companies, and hiring private investigators not to find a lover in a hotel, but to find a hidden ledger in a warehouse. But even as the financial battles peaked, a new and even more complex frontier was opening up. The 1990s were bringing the science of the soul into the courtroom. DNA testing was about to hit the legal world like a tidal wave, and the definition of a father was about to be challenged by technology. We have moved from the moral fixer to the forensic tax strategist. But the next part of our journey involves a shift that many lawyers were not prepared for: the battle for the child's mind. In the next part, we will explore the rise of the parental alienation defense and the controversial era of the psychological custody battle, where lawyers were forced to become amateur therapists in a world of high-conflict co-parenting. The courtroom was about to get a lot more crowded, and the experts were about to get a lot more expensive. The early 1990s marked a pivot point where the divorce lawyer's briefcase, once filled with bank statements and deed transfers, began to fill with psychological evaluations and diagnostic manuals. This transition was driven by a fundamental change in how the American legal system viewed the family unit. No longer was a child seen as a mere appendage of the father's estate or a natural ward of the mother. The child was now a legal subject with their own rights, and the lawyer's job was to weaponize or defend those rights depending on which side of the table they sat. This era introduced the world to the custody consultant. Imagine a citizen named David in 1992. He is a successful professional going through a divorce. In 1950, David might have expected to see his children on alternating weekends while providing a monthly check. But in the 1990s, the legal trend shifted toward joint custody. This sounds equitable in theory, but in practice it created a new theater of war. David's lawyer now had to prove that he wasn't just a provider, but a primary caregiver. This involved a step-by-step documentation of daily life that would seem invasive by today's standards. Lawyers instructed clients to keep logs of every diaper changed, every school lunch packed, and every doctor's appointment attended. The lawyer's role was to take this raw data of parenting and transform it into a compelling courtroom narrative of the psychological bond. Case studies from this period highlight the rise of the guardian ad litem. This was a third lawyer introduced into the mix, specifically to represent the interests of the child. For the primary divorce attorneys, this added a massive layer of complexity. They now had to lobby a neutral third party who was conducting independent investigations. The lawyer's strategy shifted from direct combat with the spouse to a subtle influence campaign directed at the guardian ad litem. They would curate the list of people the investigator should talk to, ensuring that the teachers, neighbors, and coaches interviewed were those most likely to speak favorably of their client's parenting style. This era also saw the controversial emergence of parental alienation syndrome as a legal defense. While its scientific validity was, and remains, a subject of intense debate in the medical community, its utility in the courtroom was undeniable for lawyers in the mid-90s. If one parent was being blocked from seeing the child, the lawyer would argue that the other parent was systematically brainwashing the child. This required the lawyer to act as a cross-examiner of children's therapists. They had to be able to look at a therapist's notes and find the specific leading questions that might have influenced a child's testimony. The divorce lawyer was now deep diving into the mechanics of memory and the suggestibility of the adolescent mind. The financial side of the 1990s didn't slow down either. It just became more high-tech. With the dawn of the digital age, lawyers began to deal with the first instances of electronic discovery. Imagine if a spouse in 1996 thought they could hide assets by communicating through early email services or keeping digital ledgers on a home computer. Lawyers started hiring the first generation of computer forensics experts. This was a significant shift in historical trends. A lawyer who didn't understand how a hard drive could be mirrored or how deleted files could be recovered was suddenly obsolete. The step-by-step process of a high-net-worth divorce now included a digital audit. This was the beginning of the end for the secret offshore account or the hidden business venture, as the paper trail became a digital one that was much harder to fully erase. Another major development in this decade was the institutionalization of the prenuptial agreement. While prenups had existed for the ultra-wealthy for decades, the 1990s saw them move into the upper middle class. Lawyers were now being asked to draft documents that anticipated the end of a marriage before it even began. This changed the lawyer-client relationship from a reactive one to a proactive one. The lawyer became a risk manager. They had to sit down with a couple in love and walk them through the potential outcomes of their demise. It required a delicate balance of legal coldness and interpersonal tact. The lawyer had to explain that they weren't just protecting money. They were creating a legal exit strategy that could prevent the very types of high-conflict battles we've been discussing. However, this created a new paradox. If a prenup was signed under duress or without full financial disclosure, it became a prime target for litigation during the divorce. Lawyers in the late 90s specialized in busting the prenup. They would look for a single missing bank account in the original disclosure or argue that the wife was pressured into signing the document just hours before the wedding. This led to a gold standard of drafting where both parties had to have independent counsel, a full audit had to be attached to the document, and it had to be signed months in advance. The role of the lawyer was to make a document bulletproof, a term that became a common part of the legal lexicon in this era. The data from the end of the 20th century shows that the duration of divorce cases was increasing. The involvement of psychologists, forensic accountants, computer experts, and guardians ad litem meant that a contested divorce could drag on for 2 to 5 years. For the lawyers, this meant a shift in business models toward the retainer and billable hour system that defines the modern industry. The 1990s divorce lawyer was a project manager of a massive, multidisciplinary team. They were the ones coordinating the various experts and ensuring that the overall legal strategy remained coherent amidst a sea of technical data. As we approached the year 2000, we also saw the rise of the international divorce. As the world became more globalized, it wasn't uncommon for a US-based lawyer to handle a case where the husband lived in Chicago, the wife lived in London, and the assets were in a trust in the Cayman Islands. This required the lawyer to be an expert in international law and treaties like the Hague Convention on the civil aspects of international child abduction. The role had evolved from a local fixer in a small-town courthouse to a global strategist navigating conflicting legal systems. Imagine if you were a lawyer at the turn of the millennium. You are dealing with a case where a spouse has abducted a child to another country, hidden millions in cryptocurrency, which was just starting to be conceptualized, and is using the internet to smear your client's reputation. This was the birth of the reputation management aspect of divorce law. Lawyers began working with PR firms to control the narrative in the media, especially in high-profile cases. They realized that a win in the courtroom could be a loss in the court of public opinion, which could affect a client's future career or social standing. We have seen the lawyer evolve from a shadow-dwelling detective in the 1920s to a sophisticated, multidisciplinary strategist by the 1990s. But as the 20th century closed, a new question began to emerge. With all this technology, all these experts, and all this complexity, had the legal system become too expensive for the average American? Was the business of breaking up actually serving justice? Or was it just serving the bottom line of the law firms? In the next part, we will look at the pro se revolution, where citizens began to fight back against the legal establishment by representing themselves, and how the legal profession had to pivot once again to survive the rise of the internet. We will also examine the secret world of legal funding, where outside investors started betting on the outcomes of divorce cases like they were playing the stock market. The final decade of the century was about to turn the entire profession upside down. The intersection of the 1990s and the looming new millennium brought about a crisis of accessibility that the legal profession had never seen before. As the complexity of forensic accounting and psychological warfare increased, so did the price of entry. By 1998, the average contested divorce in a major U.S. metropolitan area could easily reach tens of thousands of dollars in legal fees. This created a massive vacuum in the market. Imagine a citizen named Sarah in 1999. She is a middle-income worker who realizes her marriage is over. She looks at the retainer fees for a top-tier firm and realizes she would have to liquidate her entire savings just to start the process. This sparked the pro se revolution, a historical trend where individuals began walking into courtrooms without a lawyer, armed only with a stack of forms they had downloaded from early legal help websites or purchased at a local stationery store. The impact on the role of the divorce lawyer was immediate and disruptive. Judges were suddenly faced with crowded dockets filled with people who did not understand the rules of evidence or the nuances of property law. To prevent the system from grinding to a halt, a new legal archetype emerged: the unbundled consultant. Instead of taking on a full case from start to finish, lawyers began selling their services à la carte. A lawyer would charge a flat fee to review a document, or an hourly rate to provide behind-the-scenes coaching for a client who would then represent themselves in court. This was a radical departure from the traditional advocate model. The lawyer was no longer the face of the case. They were the ghostwriter. Step by step, the workflow for these lawyers changed. Instead of managing a full file, they spent their days in rapid-fire consultations. They had to develop a high level of proficiency in explaining complex legal concepts, like the difference between separate and community property, in simple terms that a layperson could execute under pressure. This shift democratized legal knowledge, but it also increased the risk of errors. Case studies from the late 90s show an increase in post-divorce litigation because pro se litigants often miss critical details, such as the specific wording required to divide a pension plan. The lawyers who specialized in fixing these botched self-filed divorces became the mechanics of the family court system. As the cost of litigation skyrocketed, the market also gave birth to one of the most controversial developments in 20th century law: litigation funding. Historically, a concept known as maintenance and champerty prevented third parties from investing in someone else's lawsuit. However, by the late 1990s, these barriers began to erode. Imagine if an investment firm looked at a high-stakes divorce case like a venture capital deal. They would provide the funds for the wife's high-priced legal team and forensic accountants in exchange for a percentage of the final settlement. For the lawyer, this was a game-changer. It meant they could take on massive, complex cases against wealthy husbands who previously could have outspent the opposition into submission. The role of the lawyer in these funded cases became even more analytical. They weren't just reporting to the client, they were essentially reporting to a board of investors. They had to provide potential outcomes reports and detailed budget projections. This brought a corporate level of scrutiny to the divorce process. Critics argued it turned the dissolution of a family into a commodity, but proponents pointed out that it leveled the playing field for spouses who had been financially sidelined during the marriage. Historical trends show that this funding model paved the way for the multi-million-dollar war of attrition, cases that dominated the headlines as the century closed. Simultaneously, the legal community was grappling with the secret world of domestic torts. For much of the century, spouses were generally immune from suing each other for civil wrongs, a doctrine known as interspousal immunity. But in the 1980s and 90s, state after state began to abolish this rule. Suddenly, a divorce lawyer wasn't just handling a contract dissolution. They were handling a personal injury case. A lawyer could now sue a spouse for intentional infliction of emotional distress, or even for transmission of an STD. This added a whole new layer to the discovery process. Lawyers had to gather medical records and psychiatric testimony that went far beyond the standard irreconcilable differences filing. Imagine if you were a lawyer in 1997 representing a client whose spouse had been leading a double life. Under the old laws, that double life might have been a minor point in a property settlement. Under the new tort-based approach, that double life could be the basis for a $1 million damage claim within the divorce itself. This required lawyers to be experts in both family law and civil litigation, two fields that had historically been kept separate. The 1990s also saw the lawyer's role as a privacy guardian become paramount. As the internet began to store more of our personal data, the deep dive became a digital dragnet. Lawyers were the first to realize that a person's search history or early social forum posts could be used to prove wasteful dissipation of marital assets. If a husband was spending thousands of dollars on an online gambling site, the lawyer had to know how to subpoena the server logs of an ISP that might be based in another country. The legal process became a race to secure digital evidence before it could be deleted with a single keystroke. Data from the end of the century suggests that the business of breaking up had become so efficient and so aggressive that the courts began to push back. This led to the mandatory mediation movement. In many jurisdictions, a lawyer could no longer just rush to court and start a fight. They were legally required to sit in a room with a neutral mediator and attempt to settle. This forced the shark lawyers to develop a diplomat persona. They had to learn how to advocate for their clients' interests without triggering the high-conflict response that would lead to a judge's reprimand. This brings us to the final, most complex transformation of the 20th century divorce lawyer: the rise of the domestic violence advocate within the private bar. While social services had always existed, private lawyers in the 90s began to integrate specialized safety planning into their legal strategy. They realized that the moment a divorce is filed is often the most dangerous time for a client. The lawyer's role expanded to include coordinating with private security, setting up escape funds that wouldn't be flagged as asset hiding, and mastering the order of protection system. The lawyer was no longer just a suit in a courtroom. They were often the only person standing between a client and a life-threatening situation. We have traced the lawyer from the staged hotel room raids of the 1920s to the high-tech, tort-heavy, investor-funded battles of the late 1990s. But as the clock ticked toward midnight on December 31, 1999, the legal world faced a new unprecedented challenge. The very technology that had made their jobs more precise was about to create a world where privacy was an extinct concept. The 21st century was bringing a tool that would change the divorce lawyer's job more than any law ever could: the smartphone. But before we get to the digital explosion, we have to look at the one thing that remained constant throughout the 100-year evolution: the human element. In our next part, we are going to look at the ethical gray zones of the 20th century divorce lawyer. We will explore the secret files of the most famous matrimonial attorneys and reveal the tactics they used to stay on the right side of the bar association while doing whatever it took to win for their clients. We'll look at the coach testimony, the hidden assets in plain sight, and the cases that led to the modern rules of legal ethics. The line between zeal and crime was often thinner than anyone wanted to admit. The ethical tightrope of the 20th century divorce lawyer was often strung across a canyon of desperation and greed. To understand how the modern rules of professional conduct were forged, we have to look at the era where those rules were barely suggestions. In the mid-century period, specifically between the 1940s and 1960s, a divorce lawyer's success was often measured by their ability to coach a witness without technically suborning perjury. Imagine a client named Robert in 1952. Robert wants a divorce, but he has no legal grounds. His lawyer knows that if Robert admits in open court that he and his wife simply want to part ways, the judge will deny the petition based on collusion. The lawyer's task, therefore, was to guide Robert through a series of leading questions during prep sessions that encouraged him to exaggerate a single argument into a claim of extreme cruelty. This practice was so widespread that it created a crisis of integrity within the American Bar Association. Case studies from this era show that lawyers would often provide their clients with scripts. They weren't told to lie, but they were told which truths to emphasize and which to suppress. If a husband had once raised his voice during a dinner party, the lawyer would frame that as a pattern of verbal abuse. If a wife had stayed out late once, it became a narrative of abandonment. This era of manufactured testimony is what eventually led to the 1983 revision of the Model Rules of Professional Conduct, which placed a much higher burden on lawyers to ensure the candor of their clients toward the tribunal. Another dark corner of the profession involved the tactical use of discovery to bankrupt the opposition. Before the modern reforms that streamlined document production, a lawyer could use a scorched earth policy. If a husband was a small business owner, The wife's lawyer might demand every single receipt, invoice, and ledger from the last 15 years. The goal wasn't necessarily to find a smoking gun. It was to create so much legal work and so much stress that the husband would settle for a higher amount just to make the nightmare stop. This was known as litigation by exhaustion. The lawyer's role was to be an economic predator. They would look for the pressure points in a person's life, their business reputation, their relationship with their children, or their credit rating, and apply legal pressure until something snapped. Historical trends in the 1970s show that this led to a massive increase in the use of the deposition as a weapon. Imagine if, in 2026, every private conversation you had was subject to being read aloud in a public record. In the 70s, lawyers began using depositions to ask incredibly invasive questions about a spouse's personal habits, sexual history, and social circles. Because the rules of relevance were much broader then, lawyers could spend 8 hours a day for a week straight questioning a spouse. The psychological toll was immense. It forced the legal community to eventually implement time limits and stricter rules on what constitutes harassment during the discovery process. One of the most complex ethical gray zones involved the hiding of assets in plain sight. Before the digital age made tracking money relatively easy, a lawyer's advice on financial management during a divorce was a high-stakes game of hide-and-seek. A common tactic was the pre-divorce spending spree. A lawyer might subtly suggest that a client upgrade their lifestyle before filing, purchasing expensive jewelry, art, or vehicles that could later be undervalued or claimed as personal property rather than marital assets. Or, even more nefariously, they might suggest deferred compensation schemes where a client would ask their employer to hold off on a bonus or a raise until after the divorce decree was signed. Step by step, these lawyers were teaching their clients how to legally manipulate the balance sheet. First, they would identify the non-liquid assets. Second, they would find ways to depreciate the value of the family business on paper, perhaps by taking on unnecessary debt or delaying new contracts. Third, they would present this diminished financial picture to the court. The lawyer's defense was always the same. They were simply providing tax and business advice. But the reality was a systematic effort to deprive the other spouse of their fair share. This led to the creation of the forensic accountant as a standard part of the legal team. By the 1980s, you couldn't just take a spouse's word for what their business was worth. You had to hire a professional to dig through the garbage, literally and figuratively. The ethical dilemmas weren't just about money, they were about the children. In the mid-80s, the silver bullet tactic emerged. This was the practice of a lawyer advising a client to make a false or exaggerated allegation of abuse at the very beginning of a custody battle to secure an immediate, ex parte restraining order. This would remove the other parent from the home and establish a new status quo of custody that could take months or years to undo. For the lawyer, it was a devastatingly effective way to win the opening move. But for the legal system, it was a poison that destroyed the credibility of genuine victims. This era saw a surge in malicious prosecution lawsuits against lawyers who were found to have encouraged these tactics. It led to the modern standard where lawyers can be personally sanctioned or disbarred for filing frivolous or bad faith motions. As we look at the potential outcomes of these ethical lapses, we see the rise of the Client Security Fund. State bar associations realized that lawyers were occasionally stealing from their own clients' trust accounts, especially when those accounts held the proceeds from the sale of a marital home. These funds were established to reimburse victims of attorney theft. It was a sobering admission that the divorce industry had, in some cases, become a haven for those who viewed their client's tragedy as a personal ATM. However, it wasn't all dark. This period of ethical turmoil also produced the moral counselor archetype. These were lawyers who realized that a divorce doesn't happen in a vacuum, and that their job was to protect the client from their own worst instincts. They would refuse to file a vindictive motion or tell a client plainly that their demands were unreasonable and would only lead to higher fees and more pain. These lawyers laid the groundwork for what we now call collaborative law. They realized that the best outcome wasn't a win in court, but a sustainable peace that allowed the family to function in a new way. Imagine if you were a lawyer in 1995. You have a client who wants to burn the world down to get back at their spouse. Your choice is to either take the retainer and start the fire, or to act as a gatekeeper for the legal system and guide them toward a more rational path. The lawyers who chose the latter were often the ones who helped craft the mediation-first policies that are now standard in many states. They understood that the role of the lawyer is not just to be a mouthpiece, but to be a navigator through the most turbulent storm of a person's life. We have explored the gritty, often morally ambiguous world of the 20th century divorce lawyer. We've seen how they manipulated the law, the facts, and the finances to gain an advantage. But there is one final piece to this puzzle. The 1990s didn't just bring ethical reforms. They brought a new type of client, the high-profile, high-net-worth individual whose divorce was played out on the evening news. This created the publicity lawyer, a professional who had to manage the judge and the press simultaneously. How did these lawyers use the media to influence the outcome of a case? How did a single leak to a tabloid change the leverage in a multi-million-dollar negotiation? In the next part, we will dive into the media-driven divorce and the rise of the trial by headline. We will look at the specific cases where the court of public opinion forced a settlement long before a judge could even gavel the court to order. We'll also look at the secret non-disclosure agreements that became the ultimate weapon in protecting reputations in the age of the 24-hour news cycle. The lawyer was about to become a PR executive, and the stakes were no longer just about the house, they were about the brand. The transition into the 1990s and the lead up to the year 2000 created a new breed of legal professional, the media strategist lawyer. In the early decades of the 20th century, a divorce was a private shame, something to be whispered about in mahogany-paneled rooms. By 1994, it was an 8-minute segment on a cable news network. The lawyer's role shifted from keeping their client out of the news to carefully curating the news to force a settlement. Imagine a public figure named James in 1996. He is a high-profile executive going through a contentious split. In this era, his lawyer's first call wasn't to the court clerk. It was to a public relations firm. They understood that a well-timed leak to a major newspaper could create more leverage than 10 motions in front of a judge. This was the dawn of the trial by headline. Historical trends show that lawyers began to use the media as an extension of the discovery process. If a husband was refusing to disclose certain business assets, the wife's lawyer might subtly mention to a reporter that a major investigation into the husband's business practices was underway. The potential outcomes of such a statement were twofold. It put public pressure on the husband to settle quietly to protect his stock price, and it signaled to the court that this was not a standard domestic dispute, but a case of significant public interest. The lawyer's task was to walk the fine line of defamation law, while ensuring their client's narrative was the one that stuck in the public consciousness. Step by step, the media strategy followed a specific playbook. First, the lawyer would identify the most damaging piece of information that was legally admissible, or at least likely to be brought up in open court. Second, they would provide a background briefing to a trusted journalist, ensuring the story broke just before a major hearing. Third, they would use the resulting media frenzy to argue that a private settlement was the only way to protect the children and the parties' reputations. This cycle turned the courtroom into a theater and the lawyer into the director. Case studies from the 1990s, particularly those involving Hollywood celebrities and New York real estate moguls, show that the mere threat of a public trial often led to settlements that were significantly higher than what the law would strictly require. This era also solidified the importance of the non-disclosure agreement, or NDA. As the value of a person's brand became a marital asset, the lawyer had to become an expert in gag orders. The NDA became the ultimate bargaining chip. A lawyer might agree to a lower alimony payment in exchange for a lifelong silence clause. This created a secret history of the 20th century where the most scandalous details of the American elite were buried in sealed legal folders. The divorce lawyer was the gatekeeper of these secrets. They had to draft these agreements with such precision that they would survive challenges decades later, in a much more digital and interconnected 2026. If a lawyer left a loophole in a 1998 NDA, they could be held responsible for a client's reputational collapse years down the line. The financial complexity of the brand divorce also introduced the role of the intellectual property specialist within the divorce firm. Lawyers had to figure out how to value things that didn't exist in physical form. How do you divide the future royalties of a television star? How do you value the goodwill of a famous plastic surgeon's name? These were the questions that defined the late 90s legal landscape. Lawyers started bringing in specialized appraisers to put a dollar amount on fame. They would look at historical trends in the client's earnings, market saturation, and even Q scores, a measurement of a celebrity's familiarity and appeal, to determine the value of the marital estate. Imagine if you were a lawyer in 1998 representing the spouse of a tech founder right before an initial public offering. The assets were on paper, the future was bright, but the marriage was failing. The lawyer had to navigate the lockup period of the stocks, the tax implications of the IPO, and the potential for a massive devaluation if news of the divorce hit the markets. This required a level of sophisticated financial planning that moved the divorce lawyer into the same league as top-tier corporate attorneys. They were no longer just matrimonial lawyers, they were high-stakes asset managers. However, the rise of the media-driven divorce had a chilling effect on the average citizen. While the wealthy were fighting over brands, the middle class was watching the cost of legal representation spiral out of control. This led to a significant increase in the summary dissolution for couples with no children and limited assets. Lawyers began to see their business split into two tiers: the high-volume, low-margin divorce mills for the masses, and the boutique war room firms for the elite. The role of the lawyer in the former was essentially data entry and procedural checking, while the latter remained an artisan of conflict. Data from this period suggests that the adversarial nature of these high-profile cases actually led to a cultural backlash. The public began to tire of the shark persona, leading to the rise of the kind divorce movement, which would eventually evolve into the conscious uncoupling trends of the future. But in 1999, the sharks were still very much in the water. The legal strategy was still focused on winning through superior resources and psychological dominance. Lawyers would hire jury consultants, even for bench trials where a judge made the final decision, simply to understand the psychological biases of the judge. This period also saw the divorce lawyer becoming a frequent guest on talk shows and news panels. They were no longer just practitioners, they were commentators on the state of the American family. This visibility gave them a new kind of power. A lawyer who was a regular on a major news network could use that platform to signal their expertise and attract even wealthier clients, creating a self-reinforcing cycle of fame and high-value litigation. They were the first influencer lawyers, long before the term existed. As we look at the potential outcomes of this media-saturated era, we see a legal system that was increasingly focused on the optics of justice, rather than the substance. The lawyer's job was to ensure their client looked like the victim, even if the facts were messy. They used the tools of modern marketing, focus groups, image consultants, and media training to prepare their clients for the witness stand and the courthouse steps. The divorce lawyer had successfully integrated the methods of political campaigning into the dissolution of marriage. But even as the cameras rolled and the NDAs were signed, a new challenge was emerging that the lawyers of the 1990s were ill-equipped to handle. The digital revolution was moving from the office to the pocket. The very first consumer mobile phones were becoming common, and with them, a trail of text messages and location data that would make the private investigators of the 1920s look like children with magnifying glasses. The lawyer was about to lose control of the narrative because the evidence was becoming decentralized. We have seen the lawyer as a media mogul and a brand protector, but the next part of our journey takes us into the heart of the digital transformation. How did the rise of the early internet and mobile technology change the discovery process forever? What happened when a spouse could track their partner's every move with a simple GPS device? In the next part, we will explore the electronic war of the late 90s and early 2000s, where the divorce lawyer had to become a digital detective. We'll look at the first cases of email spying and the legal battles over digital privacy within a marriage. The curtains were being pulled back in a way that no lawyer could stop, and the truth was about to become a lot more complicated to manage. The year was 1999, and the legal world was standing on the precipice of a data explosion that would render the traditional private investigator's telephoto lens nearly obsolete. For decades, the divorce lawyer relied on physical surveillance and paper trails. But as we entered the final turn of the century, the briefcase began to be replaced by the computer tower. This was the era of the digital forensic pioneer. Imagine a citizen named Michael in 1999. He suspects his spouse is hiding a significant portion of their marital assets in a burgeoning offshore digital entity. In 1979, his lawyer would have hired a private eye to dig through a dumpster for discarded bank statements. In 1999, that same lawyer was hiring a specialist to mirror a hard drive. The historical trends of this period show a sudden, sharp pivot toward electronic discovery, or e-discovery. This wasn't just about reading emails, it was about the metadata. Lawyers realized that every digital file carried a fingerprint. A spreadsheet showing a lower business valuation might have a metadata tag showing it was created just 48 hours after the divorce papers were served. The lawyer's role became that of a digital archaeologist. They had to understand the difference between a deleted file and a wiped file. They had to argue in court about the admissibility of data recovered from unallocated space on a hard drive. This was a high-stakes technical battle that most judges in 1999 were completely unprepared for, requiring lawyers to spend hours educating the bench on how computers actually store information. Step by step, the discovery process was overhauled. Step 1. The preservation letter. Lawyers had to act faster than ever, sending immediate notices to spouses and their employers to prevent the routine deletion of server logs and email archives. Step 2. The forensic image. The lawyer would coordinate the seizure of a computer, ensuring a bit-for-bit copy was made so as not to alter the original evidence. Step 3. The keyword search. Instead of reading thousands of papers, lawyers were now running scripts to find terms like offshore, transfer, or even the names of suspected paramours. This efficiency changed the potential outcomes of a case from a months-long guessing game to a precise strike based on cold, hard data. Case studies from the late 90s reveal the first major legal battles over the Wiretap Act in the context of marriage. Many lawyers were faced with clients who had installed early versions of keylogger software or spyware on the family computer. The ethical and legal question was clear. Does a spouse have an expectation of privacy on a shared home computer? Some lawyers argued that the computer was a communal asset like a kitchen table, and therefore anything on it was fair game. Others argued that intercepting private communications was a federal crime. This led to a fragmented legal landscape where the role of the lawyer was to navigate the gray areas of emerging privacy law. A lawyer who used illegally obtained digital evidence risked not only losing the case but facing personal criminal charges or disbarment. This digital shift also introduced the concept of the electronic trail of spending. Before the ubiquitous use of debit cards and online banking, cash was king and cash was hard to track. By the end of the 90s, almost every transaction left a digital footprint. Lawyers began to specialize in analyzing credit card processing data to find patterns. They could see the exact time a spouse checked into a hotel, the flowers they bought that never made it home, and the secret cell phone bills paid for from a secondary account. The divorce lawyer became a data scientist, correlating timestamps from cell towers with credit card swipes to create a minute-by-minute map of a spouse's activities. Imagine if, in 2026, you could look back and see how these early digital battles shaped our modern understanding of consent and surveillance. In the year 2000, we saw the first cases of location tracking. While GPS was not yet in every pocket, it was being surreptitiously attached to vehicles. Lawyers had to argue whether tracking a car on a public road constituted an invasion of privacy. These arguments laid the groundwork for the privacy laws that govern our smartphones today. The divorce lawyer was at the front lines of defining the boundaries of the digital self. The financial side of the digital war was equally intense. As businesses moved their accounting to software like QuickBooks, the opportunity for accounting manipulation changed. A lawyer's deep dive now involved looking for ghost employees on a digital payroll or diverted funds in an electronic ledger. Forensic accountants working for divorce firms developed specialized software to detect anomalies in digital records that would be invisible to the naked eye on a printed page. This increased the cost of litigation significantly, as a single case might require dozens of hours of expert data analysis. However, the technology wasn't just a tool for the lawyers, it was a weapon for the spouses. The rise of early social media and message boards meant that a spouse's public presence could be weaponized. Lawyers began monitoring chat rooms and early community sites for admissions of guilt or evidence of a lifestyle that contradicted the financial disclosures made in court. The social media clause began to appear in settlement agreements, where lawyers would negotiate for the removal of certain photos or the cessation of cybersmearing as part of the final decree. The lawyer was now a digital reputation manager, trying to scrub the internet of evidence that could damage their client's future. Data from the turn of the millennium suggests a massive increase in the volume of evidence presented in court. Where a file might have once been 2 folders thick, it was now 3 boxes of printed emails and computer logs. This forced the legal system to move toward electronic filing and digital courtrooms. The lawyer had to be the most tech-savvy person in the room, capable of presenting a digital exhibit on a projector when the judge was still used to looking at physical photographs. Those who failed to adapt were quickly pushed out of the high-stakes market. This era also saw the birth of the e-divorce. In some jurisdictions, lawyers began pushing for the ability to serve papers via email, or to conduct certain hearings via video conference. While this was rare in 1999, it showed a historical trend toward a more remote, automated legal process. It began to strip away the personal, often performative nature of the courtroom, and replaced it with a more clinical, data-driven experience. The lawyer's role was becoming less about the oratorical flourish and more about the precision of the technical filing. We have seen the lawyer evolve from a shadow-chasing detective into a digital forensic master. We've watched them navigate the transition from paper ledgers to encrypted hard drives. But as the 20th century officially closed and the 21st century began, one final evolution was taking place. The legal profession was about to face a crisis of identity. With all this data and all this technology, had the human element of divorce, the grief, the anger, the transition of the family been lost? In our next part, we will explore the great pivot of the early 2000s, where a new generation of lawyers began to rebel against the high-conflict, high-cost digital war. We will look at the rise of holistic law and the collaborative divorce movement, where lawyers took a pledge to stay out of the courtroom entirely. Was this a genuine attempt to save the American family? Or was it just a new way to market legal services in a saturated digital world? And most importantly, we will look at how the children of the divorce revolution, the kids whose lives were mapped out in those early digital battles, began to change the laws themselves as they reached adulthood. The legacy of a century of legal combat was about to be challenged by the very people it was supposed to protect. As the 20th century closed its doors, the scorched earth tactics that defined the 1980s and 1990s hit a wall of human exhaustion. The legal profession reached a breaking point where the financial and emotional cost of a standard contested divorce was no longer sustainable for the American middle class. This gave rise to a radical movement that would redefine the role of the lawyer once again: the collaborative divorce revolution. Imagine a citizen named Christopher in the year 2000. He and his spouse have decided to end their marriage, but they have watched their friends spend 3 years and $200,000 in legal fees only to end up hating each other. Christopher seeks out a new type of professional, the collaborative attorney. This was not just a change in strategy, it was a change in the legal contract itself. In a collaborative case, the lawyers and the client sign a participation agreement that states if the case goes to court, both lawyers must be fired. This was a revolutionary historical trend. For the first time in a century, the lawyer's financial incentive was aligned with settlement rather than litigation. The lawyer's role shifted from a gladiator to a facilitator. They were no longer preparing for a trial. They were preparing for a series of four-way meetings designed to solve problems rather than win arguments. The step-by-step process of the collaborative model was a masterclass in interdisciplinary cooperation. Step 1: the team assembly. A collaborative lawyer would often work alongside a neutral financial specialist and a child specialist, usually a psychologist. Step 2: the interest-based negotiation. Instead of demanding a specific asset, the lawyer would ask the client to identify their underlying interest. For example, instead of demanding the house, the interest might be stability for the children. Step 3: the creative brainstorming. The lawyer's job was to find solutions that a judge, bound by rigid statutes, never could. This might include delayed house sales, shared nesting arrangements where children stay in one home while parents rotate in and out, or creative tax sharing agreements. Case studies from the early 2000s show that while these cases often took a similar amount of time to resolve as traditional divorces, the potential outcomes were vastly different. The post-divorce litigation rate, the frequency with which couples return to court to fight over custody or support, dropped significantly in collaborative cases. Lawyers in this niche became experts in communication theory and conflict resolution. They were no longer just reading the law, they were reading the room. They had to manage high-conflict personalities without the threat of a judge's gavel to keep order. However, this shift toward peace was met with significant skepticism from the old guard. Traditional shark lawyers argued that collaborative law was a violation of the attorney's duty to be a zealous advocate. They worried that by taking the threat of court off the table, lawyers were leaving their clients vulnerable to a more aggressive or dishonest spouse. This tension created a split in the profession that remains visible even in 2026. The divorce lawyer was forced to choose a camp. Were they a warrior or a peacemaker? As the children of the divorce revolution, those whose parents split during the high-conflict eras of the 70s and 80s, began to enter the workforce and the voting booths. They brought with them a deep-seated desire for reform. They had lived through the yearly custody battle and the forensic audit of the childhood bedroom. This demographic shift led to the rise of the presumptive 50-50 custody movement. Lawyers began to see a wave of legislation across various states that moved away from the primary caregiver model toward a legal presumption that equal time with both parents was in the best interest of the child. This change in the law fundamentally altered the lawyer's leverage. In the 1990s, a lawyer representing a mother could often use the threat of limited visitation to negotiate a better financial settlement. By the early 2000s, that leverage was evaporating. The lawyer's role was now to help parents navigate the logistical nightmare of a 50-50 split. They became consultants on parallel parenting and co-parenting apps, which were just beginning to hit the market. The lawyer had to draft parenting plans that were so detailed they accounted for every holiday, every transition time, and even the right of first refusal if a parent needed a babysitter. The data from this transition period shows a massive increase in the complexity of these documents. A custody agreement in 1960 might have been 2 paragraphs long. By 2005, a comprehensive parenting plan could easily be 30 pages of fine print. The lawyer was essentially drafting a constitution for a new 2-household family. They had to anticipate every possible conflict point to keep the family out of court in the future. Simultaneously, the financial role of the lawyer was being challenged by the pro se movement we discussed earlier, which had now evolved into LegalZoom and other online document preparation services. To survive, the high-end divorce lawyer had to offer something technology couldn't: sophisticated judgment and emotional intelligence. They began to market themselves not as form fillers, but as holistic advisors. They would help a client manage the sale of a business, the restructuring of a trust, and the psychological transition of the family all at once. One of the most profound shifts in this era was the lawyer's role in the gray divorce. Divorces among couples over the age of 50. As life expectancy increased and social stigma decreased, the 20th century ended with a surge in long-term marriages dissolving. The lawyer for a gray divorce had to be an expert in Social Security law, Medicare, and complex pension valuations. They were no longer fighting over who got the toddler. They were fighting over who got the survivor benefits of a 30-year career. These cases were less about the heat of passion and more about the cold reality of retirement security. Imagine if you were a lawyer in 2004 representing a woman who had been a homemaker for 40 years and was now facing a divorce. Your role was to ensure she didn't fall into poverty in her 70s. This required a deep understanding of alimony buyouts and qualified domestic relations orders. You were essentially an insurance agent for your client's old age. The historical trends show that the divorce lawyer became a critical component of the American social safety net for aging women. As we look at the legacy of the 20th century divorce lawyer, we see a profession that mirrored the evolution of America itself. We moved from a society of rigid moral judgment to one of complex financial and psychological negotiation. The lawyer was the guide through this transformation, sometimes the villain of the story, but often the only person who knew how to bridge the gap between two lives that had become hopelessly entangled. But there is one final chapter. As we reflect on 100 years of legal warfare and reform, we have to ask, what did it all lead to? What does the modern landscape of 2026 owe to the collusion architects of the 1920s and the digital forensics masters of the 1990s? And more importantly, as AI begins to enter the legal field, is the era of the human divorce lawyer coming to an end? In our final part, we will bring the entire century into focus. We will look at the ultimate legacy of the 20th century divorce lawyer and how their work fundamentally changed the American concept of liberty. We will also reveal the one secret that every divorce lawyer knows but rarely tells their clients. The secret that explains why, despite all the changes in law and technology, the process of breaking up remains the most difficult thing a human being can do. We are going to look at the future of the profession and the final verdict on a century of domestic law. The story ends where it began, in the human heart, but with a significantly more expensive paper trail. The cumulative weight of 20th century divorce law is not just found in the leather-bound volumes of case law, but in the structural DNA of every modern American family. As we stand in 2026, looking back at the 100-year evolution we have just traversed, we see that the divorce lawyer was more than a legal representative. They were the primary architects of a new social contract. To understand the final verdict on this century of domestic law, we must look at the transition into the year 2000 as the ultimate stress test for the legal profession. The legacy of the 20th century divorce lawyer is defined by the shift from moral judgment to economic management. At the start of the century, the lawyer was a gatekeeper of morality. By the end, they were a liquidator of partnerships. This change reflects a fundamental shift in the American concept of liberty. The right to leave an unhappy union became as vital as the right to enter one. Imagine a citizen named Alex in 1999, finalizing a divorce that would have been legally impossible for his great-grandfather. Alex's lawyer didn't argue about his soul. They argued about his 401k, his home equity, and his parenting schedule. This transition represents the secularization of the family unit in the eyes of the law. Historical trends show that the most significant outcome of this century-long legal battle was the total professionalization of the breakup. In 1910, you might have consulted a general practitioner or even a clergyman. By 1999, you needed a team: the lead counsel, the forensic accountant, the child psychologist, and the tax advisor. This specialization was a direct response to the increasing complexity of the American middle class. As families accumulated more wealth, homes, stock options, pension plans, the stakes of a divorce moved from the emotional to the existential. The divorce lawyer's role was to ensure that the dissolution of a marriage didn't mean the total financial ruin of the individuals involved. However, this professionalization came with a cost that the legal system is still grappling with in 2026. Data from the late 90s indicates that the average cost of a litigated divorce grew at a rate that far outpaced inflation. The divorce lawyer became a luxury that many could barely afford, leading to the massive pro se movement we discussed. This created a two-tiered system of justice, one for those who could afford the forensic deep dive, and one for those who had to navigate the labyrinth of family court alone. The final verdict on the century must acknowledge this disparity. The lawyer became a powerful ally for the wealthy, but their very presence made the system more intimidating for the average person. Let's look at a final case study that encapsulates the end of this era. In 1998, a landmark case in New York challenged the valuation of a celebrity's enhanced earning capacity. The lawyer argued that the spouse who stayed at home was entitled to a percentage of the other's future fame and success. This was the ultimate evolution of the lawyer as a financial architect. They were no longer just dividing what was built. They were dividing the potential of what was yet to come. This case set a precedent that influenced how professional degrees and celebrity brands are handled in 2026, proving that the work of 20th century lawyers continues to dictate the distribution of billions of dollars today. Step by step, the 20th century transformed the divorce lawyer into a project manager. Step 1. Triage the emotional crisis. Step 2. Secure the digital and physical assets. Step 3. Manage the public and private narrative. Step 4. Negotiate the exit strategy. This workflow is the standard today because of the hard-won lessons of the 1970s and 80s. The lawyers of the past century learned through trial and error, and thousands of hours of courtroom combat, that a successful divorce is not about winning, it's about a sustainable transition. Imagine if, in 2026, we relied on the laws of 1926. A woman would likely lose her children if she were found to be at fault. A man would lose his livelihood to alimony payments that never ended. The divorce lawyer of the 20th century fought the battles that ended these draconian practices. They were the ones who pushed for the best interests of the child standard, replacing the old tender years doctrine, which had biased courts toward mothers, and the paternal rights doctrine, which had favored fathers. They created a more gender-neutral, fact-based system. Yet, there is a secret that every veteran divorce lawyer from the 20th century knows, a secret they rarely shared in their marketing materials. No matter how sophisticated the law becomes, no matter how many forensic accountants you hire, the legal system is a blunt instrument for a delicate human problem. The century ended with the realization that the law can divide a bank account, but it cannot heal a heart or fix a broken family dynamic. This realization led to the rise of mediation and collaborative law, an admission by the legal profession itself that the adversarial model had reached its limit. As we look toward the future, the legacy of these 20th century pioneers is being challenged by artificial intelligence. In 2026, many of the tasks that took a 1990s lawyer weeks, searching for hidden assets or drafting a standard parenting plan, can be done in seconds by an algorithm. But the human divorce lawyer of the 20th century provided something an AI cannot: empathy tempered by cold legal reality. They were the ones who sat in the office at midnight with a client who had lost everything, providing the grounded, professional guidance needed to see a path forward. The final verdict is this: the 20th century divorce lawyer was a necessary, if often polarizing, figure in the evolution of American society. They took the messiest, most painful aspect of the human experience and built a framework of rules, protections, and procedures around it. They turned a private tragedy into a legal process, ensuring that the business of breaking up was handled with a level of rigor that protected the rights of the individual. They were the warriors of the domestic front, and their influence is visible in every child support check, every custody schedule, and every prenuptial agreement in America today. The story of the divorce lawyer is the story of how we learn to fail at marriage more fairly. It is a story of greed, empathy, strategy, and survival. As we close this documentary series, we have seen the profession move from the hotel room raids of the 1920s to the digital forensics of the 1990s. We have seen the role shift from fixer to architect. But while the century of the lawyer has ended, the age of the family is still evolving. In our upcoming bonus content, we will take a speculative leap into the next 50 years. How will the rise of virtual assets and decentralized finance change the deep dive of 2050? What happens when a marriage is dissolved entirely through a smart contract on the blockchain? The 20th century was just the beginning. The next era of family law is already being written in the code of our digital lives, and the lawyers are already sharpening their digital tools for the next great transformation of the American home.